Chapter 2, Statutory Analysis. This course is based on a statute. Therefore, Chapter 2 teaches how to analyze a statute and apply it to solve a legal problem. Not only is this an important skill for you to learn for this course, but it is also a critically important skill for lawyers in practice. You may have already been introduced to the skill of statutory analysis in other law school classes. If so, some of the material in this chapter will appear to be somewhat basic. However, many students have never had an opportunity to focus on reading and applying statutes. Therefore, this chapter gives all students the opportunity to gain or refine their existing statutory analysis skills. This chapter uses UCC Article 2 as an exemplar statute to teach the process of statutory analysis. This analytical approach will accelerate your ability to read and understand Article 2. Part 1, the anatomy of a modern statute. New law students learn that most appellate opinions contain the same parts in more or less of the same order: facts, procedural history, issue, etc. Students look for these parts when they read cases and organize their case briefs around them. Similarly, most modern statutes and regulations exhibit a uniform structure, like cases, statutes contain basically the same parts in basically the same order. Using the parts, students can brief or deconstruct a statute just as they brief a case. Occasionally, a statute may lack one of these parts, but you can usually find its function being fulfilled by other parts. These parts usually appear in the order shown in Figure 2-1. Purpose, with the definition of purpose, scope, exclusions, definitions, operative provisions, and consequences. Purpose. Why was the statute enacted? This part states the legislator's purpose in enacting the statute and is intended as an aid to interpretation and application. It may include legislative findings about the problems the statute was intended to solve. A statute that is the result of political compromise may assert several inconsistent purposes. Some statutes omit a purpose provision, necessitating recourse to legislative history. Others simply recite whatever legislative purpose is necessary to the statute's constitutionality. Scope, aka applicability. What kinds of events or persons does the statute apply to? Some statutes omit the scope provision, and the scope must be deduced from the next three parts, which are exclusions, definitions, and operative provisions before consequences. Exclusions. What things that would otherwise be in the scope of the statute are excluded from its coverage. Exclusions often reflect either the existence of conflicting regulations or the political victory of some special interest. Sometimes exclusions are combined with the scope section, and sometimes they are hidden in or inferable from the definitions. Definitions. What do the words of the statute mean? Defined words are the terms of art the statute uses. The more modern the statute, the more terms it will define. A defined term is like an algebraic sign whose definition should be plugged into the statutory formula wherever the defined term appears. The more modern the statute, the more technical and less intuitive will be the definitions, and the more you'll have to be careful to keep them in mind in applying the statute. Developing dexterity in this part of the analysis will also assist transactional attorneys in their day-to-day practice generally, since almost all agreements used to document transactions incorporate the use of defined terms to some degree. Operative provisions. What does the statute do? Operative provisions serve as the motor that drives the statute. They usually takes one of three main forms. One, they prohibit or require certain acts. Thou shalt not kill. All contracts by minors are voidable. 2, they state requirements. A lender must file a financing statement to perfect a security interest. 3, they state the consequences of an act or omission. Any lender who omits to state the rate shall forfeit its claim to interest. You can think of the operative provisions as containing the elements of the rule that, if satisfied, lead to a legal consequence. Consequences. What happens if the statute is complied with or violated? The consequences include private remedies for violating the statute, public penalties for violation, and the legal effect of the actions and omissions that the operative provisions describe. Figure 2-1 describes the parts you may expect to find in a modern statute. Not every statute, however, has exactly one of each of these parts. For example, sometimes there is no specific scope provision, or there may be more than one section that states rules following. Sometimes the same section that states a rule also states the consequences for following or not following the stated rule. Sometimes the consequences are stated separately. Furthermore, most statutes contain other less important parts. The title names the statute, the update tells when the statute goes into effect and what events it applies to. Repealer provisions eliminate inconsistent legislation. Transition provisions explain how to transition from a previous law to a current statute. Some statutes contain explicit instructions on how to interpret or construe them. A severability clause reserves the rest of the statute in part. If part of it is declared to be invalid, remedies may be made subject to statutes of limitations. Certain courts may be given subject matter jurisdiction of enforcement actions. There's an exercise to identify parts of a statute. Part 2, statutory language, rules versus standards. As you work with statutes, keep in mind the difference between statutory rules and statutory standards. Statutory rules attempt to describe with precision the type of permitted or prohibited activity. Statutory standards, on the other hand, are more vague. Each has its own advantages and disadvantages. Rules give greater certainty and predictability, but have little flexibility and are often arbitrary. Standards are more flexible, but give less certainty. People are encouraged to behave right up to the edge of a rule, but example, if a statute permits driving up to 55 miles per hour, they will drive at 54.5 miles per hour. Standards may have more deterrent power at the edge precisely because they are more vague. For example, if a statute provides for driving at a speed reasonable under the circumstances, drivers may drive slower in appropriate weather conditions. Figure 2-2 gives examples of common statutory rules and standards with which you may already be familiar, and add some examples of each taken from UCC Article 2. So this gives the two examples that I just read for rule and standard. The UCC is replete with the most common legal standard, reasonableness. Sometimes it appears 3 or 4 times in the same sentence. The problem is the lack of predictability that this standard creates. Part 3, types of statutory disputes. The 6 general types of disputes that involve statutes are shown in Figure 2-3, which is a dispute about the facts, what happens. Disputes over the validity of a statute. Is it constitutional? Was it implicitly repealed? Is it preempted by federal law? Third, disputes over the choice of law to be applied to the dispute. Does California tort law apply to a plane crash in Oregon? 4, disputes about classifying real-world events in the terms used by the statute. For example, is a mobile home a motor vehicle? Was a defendant's reliance reasonable? 5th, disputes about statutory interpretation. Does subsection B create an exception to the general rule in Part 2? Are these requirements to be read in the disjunctive or conjunctive? And 6, disputes about whether the court should recognize a non-statutory exception to the literal application of a valid statute. Should a murderer be permitted to inherit from the estate of his victim under the inheritance statutes? Should the court recognize an equitable defense to liability under the Sherman Act? So to repeat the general types of statutory disputes: facts, validity, choice of law, classification, interpretation, and non-statutory exceptions. The types of statutory disputes described earlier are not conceptually watertight. For example, most disputes about classification can be recast as disputes about interpretation and vice versa. And an argument about an exception to the statute may be recast as one about classification or interpretation, but most arguments still seem to take one of these forms, and some disputes will involve more than one of the forms. The different part of the statute come into play in the typical statutory dispute. Thus, in deciding what the meaning of a term is in a classification dispute, you can often get guidance from the purpose clause or the definition. To decide whether to create an exception to the statute, you might be able to make arguments from the purpose clause or the exclusions. Part 4, statutory analysis generally, which is divided into basic steps. Step 1, scope. Step 2, deconstruct the statute. Step 3, define the terms. Step 4, apply the statute to your facts. Step 5, linking up. And Step 6, consult secondary sources. So for scope, Step 1, determine whether statute applies to the problem at hand. Most statutes contain provisions that define their applicability. Step 2, deconstruct the statute. The process of deconstructing a statute is the same as the process of identifying the elements of any rule of law. Every law student develops his or her own way of effectually deconstructing or elementizing a rule. I suggest that you always read the statute aloud and use punctuation as a key to help identify the parts or elements of the statutory rule. Step 3, define terms. Many statutes contain definitions of key terms. The definitions of some terms may refer to other defined terms. The definitions may conflict with ordinary usage. Indeed, in some statutes, the definitions may change from part to part. Some key terms may not be defined at all. Definitions should be treated like any other rule statements. Statutory legal analysis, they quote and apply definitions to the facts of the issue to reach a conclusion. Step 4, apply the statute to your facts. Once you've elementized the rule, Step 2, simply discuss each element in order. Linking up. Generally, when students have done legal analysis as a common law problem, they work with only one legal rule and maybe an exception to it. But many statutes will require reference to more than one section. Several provisions may apply to the analysis of one problem. And students will need to go through Step 4 for several different sections. They will have to link one provision to another until they construct a logical chain leading to their conclusion. Step 6, consult secondary sources. Just as in any legal analysis, secondary sources may be extremely helpful in the statutory analysis. Statutory analysis under UCC. Disputes under the UCC can be of any of the 6 types discussed in earlier. Disputes over validity can occur when the code as state law is preempted by federal legislation or when a party challenges the constitutionality of code provisions, such as those relating to self-help repossession. Most code disputes are of the 4 other types: factual, classification, interpretation, and exceptions. In real-life litigation, factual disputes usually predominate. If you can prove what happened, you win. Most problems presented in law school eliminate factual disputes by requiring that you assume an agreed-upon statement of facts. Thus, most issues you will encounter in this course are one of the 3 remaining types. To successfully analyze a UCC problem, you must be able to read statutory language closely and carefully in light of terms of art defined in statute is very important. Discovery of the appropriate language in the statute and identification of and application of the statute to appropriate facts lead to a solution. This analytical process resembles the common law reasoning that you learn in your legal writing course and in doctrinal courses such as contracts. This reasoning will be bolstered by the special policies of the UCC that become apparent from the official comments, case law, and legislative history. Part 5.2 is a UCC statutory analysis. For 2-102, which in scope contains both inclusionary and exclusionary provisions. Step 2, deconstructing the statute into giving the instructions of reading it out loud, deconstructing into elements, so the whole thing is written out as a paragraph, say it out loud, then break it up into subparts. So the prefatory clause, quote, unless the context otherwise requires, end quote, modifies the entire remaining body of the statute. For now, let's translate it to mean after you go through all of the work. Okay, I'm just going to read the paragraph. Unless the context otherwise requires, this article applies to transactions in goods. It does not apply to any transaction which, although in the form of an unconditional contract to sell or present sale, or present sale is intended to operate only as a security transaction, nor does this article impair or repeal any statute regulating sales to consumers, farmers, or other specified classes of buyers. So defining the terms of that would include what's transaction, what's reasonable, and probably to go to some different areas for cross references. Look to the purpose of the policy for direction in defining those terms of art. Consult treaties and case law to determine the meaning of undefined terms. Step 4, apply the statute to your facts. I'm not going to go into this section. Linking up and consult secondary sources are the last 2 steps. Talking in linking up about how the UCC is an integrated code. At a minimum, you will have to refer to definitional sections along with operative sections. Consult secondary sources. We did talk a little bit about that, and White and Summers is a good treatise, uniformly recognized. All right. Section 6, conclusion, statutory analysis, and the UCC. The preceding brief survey demonstrates that statutory analysis is simply another branch of legal reasoning and analysis that all law students study throughout their law school careers. The main difference is the relatively easy accessibility of the black letter law and statutes. With practice, as demonstrated in Figure 2-4, students can learn to deconstruct statutes into elements and apply the relevant facts to each element. The UCC is a good statute to use as the basis for your statutory analysis skills. Legal analysis of a sales problem should always begin with the determination of whether the statute is applicable. Thereafter, students should identify the individual code sections that are relevant to the analysis of the problem at hand and demonstrate how those sections link up. In some cases, there may be a dispute other than the interpretation of a particular section or even a question regarding its applicability. Such disputes can be resolved by reference to the code's underlying purposes and policies, as well as the case law and commentaries by learned academics and practitioners. Finally, in some situations, none of the code provisions discloses any obvious rule that would apply to your facts. If the issue in question falls within such a gap, you should first say so and then proceed to try to fill the gap with other sources of law. Supplementary principles of law and equity apply under sections 1-103. You might reason by analogy to other code provisions or from the general philosophy or articulated policies of the code. There's another exercise. And additional resources. Exercise sets forth facts and implicates section 2-102, 2-105, and 2-107, and asks for a written response.